Lochan Shastri, I'll start with you. You believe this is a day to smile, a historic day. The voters' right to know has been announced. Is that the reason why you're celebrating? Because many believe it's not going to change the system of cash funding our elections.
It's a day to celebrate. It stems the rot. It doesn't solve all the problems. And the problem of black money was there before the electoral bonds. It was there during the electoral bonds. And it is still there today.
So what should we be celebrating today according to you?
See, this transparency which had been blocked, and we don't know what happens behind closed doors, and things could have gone from bad to worse. The Supreme Court has put a check on that. So now we are back to a more transparent system.
You're back to a more transparent system, but just let me bring in Dr. Qureshi on that. Dr. Qureshi, do you share the optimism that we are back to a more transparent system? There are those who fear that corporates now will simply not give money by check as they did under electoral bonds because they didn't want their names disclosed. Now, with their names being disclosed, they'll be reluctant to give money by check, especially to the opposition.
Well, I'll agree with Professor Shastri, but with a modification that even earlier, before the bond, there was no transparency, and ADR itself was protesting about it because 70% of all donations were reported to be in cash, which was not transparent, which is what the bond scheme tried to tackle. However, it is very important for us to recall the speech of the finance minister when he introduced it through the budget speech. His very first sentence is very important to remember. He said, without transparency of political funding, free and fair elections are not possible. Very good. That's what we have been saying. Second sentence also equally good, that for 70 years we have failed to achieve that transparency. Now, we expected the third sentence to bring in transparency. It did just the opposite. It said now we will have electoral bond, and the impact of it was that whatever transparency which then existed would be done away with. And what was the transparency then? That any donation of more than 20,000 rupees, just 20,000 rupees, was to be reported to the Election Commission. Election Commission would certify that report, and on that basis, they will get income tax exemption. Now, 20 crores, 2,000 crores, anything is a secret. Now, is that the transparency which they tried to bring in?
So you're saying this electoral bond scheme would have worked provided it had been made transparent. If what was given to State Bank of India, the donors' names would have been revealed, it would have been the ideal way to actually work the system. Subhash Chandra Garg, as someone who was working with Arun Jaitley on this scheme, was that the flaw in the system? That you told corporates, you can give these bonds through State Bank of India, your names won't be disclosed. But the government could have access to the names, no one else would.
See, this was the main feature of the scheme. And you need to contrast it with what the system was prevalent earlier, which was a complete opaque system. The corporates were giving donations to the political parties, but they were giving it by sort of converting it into cash and then breaking it to all numerous donations for less than 20,000 rupees each. So that was an opaque system, which the government of the day tried to make it more transparent. It's not a fully transparent system, but more transparent system that you are making donations from your KYC-compliant bank account. The political party is receiving it into their bank account and then spending it by way of check. So it's a...
No, but what stopped you, if I may ask Mr. Garg, from telling the corporates that or telling State Bank of India that every year you will have to disclose the names of the individuals who've given the money through electoral bonds? That would have sorted out the problem.
So that is the simple clinching factor. If you do this, then this scheme is nothing different than the earlier Company Act scheme, which was prevalent there, where you made the donations by disclosing to whom you are giving. and that was not working.
No, it was not working, therefore, because, Mr. Garg, sorry to press you on this, because corporates did not want their names disclosed. The truth of the matter is, that's the really nub of it. Corporates don't want to disclose to political parties, don't want to donate if their names are disclosed. Am I correct? That's the difference between India and America.
So that is the precise problem which was being tried to be solved. If you have this as a problem, that the corporates are not willing to sort of disclose their names, and that is why the scheme was inoperative. If you have the same feature in the electoral bond,
Right.
the electoral bond scheme would also be non-starter.
Okay, let me come to specifics. Vishwajit Bhattacharya, I want short, sharp, two legal answers from you. Number one, can the government go and pass an ordinance striking down what the Supreme Court has done? Is that a possibility before the Lok Sabha elections? Do you see that happening? Yes or no?
The government will try its best. Government will try its best to get over this inconvenient judgment, but government will fail.
No, so is the ordinance route possible?
Ordinance route, you see, because Article 123 of the Constitution of India, all that the government has to do is the Union Cabinet will have to sit and send its recommendation to the President, and the President will sign. Now, then the matter goes to court. And after this kind of an emphatic verdict by a 5-judge bench, historic verdict, brilliant verdict, I think the government will fail in court again.
Okay, number two legal point. There are corporates who donated under this electoral bond scheme on the basis that their names would not be disclosed. Now the Supreme Court is saying names will have to be put up on a website of the ECI. Can therefore the government or indeed some of these corporates go and say, look, this is a violation of the commitment or the promise of the original scheme. You can't suddenly now disclose our names. Can they say that?
There is no right higher than the majesty of the Supreme Court 5-judge bench's order. It is a constitutional command articulated by the highest constitutional court of the country. This argument is as sort of frivolous as a petty contractual right.
Can they take a review? Can they seek a review on this basis? Can they seek a review of this order on this basis?
Of course they will review, and it will be thrown out. It should be thrown out with exemplary cost.